Ah. We're so glad you could join us this evening for our weekly Nation on Fire webinar, folks. If you can't hear us, we had put up the slide to show you how you access the audio for the call. And you can also find us on our social media sites. We have many of them. They are always active. PatriotCoalition.com, Twitter, Facebook, you name it, we've got it. Tonight we're doing a show that's really near and dear to my heart, but I think it is to every parent out there especially. We're going to be talking about the Parental Rights Amendment, HJR 50. This is active legislation in Congress as we speak. So we're going to take you through what this is, what it says, what it means, and how this affects you as a parent and more importantly, the relationship you have to your children. When I first heard about this amendment, as I was getting into education reform as a policy issue, I thought, wow, that just sounds so sensational. This is great. Except something kept ticking back to me that just, I think everybody, when something just doesn't feel right, if you're a parent, you get that right away. Something is strange here. And so the more I looked at it, the more I thought, well, this is just the most bizarre thing. And it probably wouldn't have raised the hair on the back of my neck nearly as much if it hadn't been for the fact that several things had happened all at the same time, which was Common Core was being rolled out. And so we now had seen the really beyond what had happened even with healthcare, the federalization, which goes against, by the way, 4 other federal laws, the federalization by the federal government of our education system. And the fact that it was so clear to parents, teachers, administrators, academics, children, that this was horrifying, Congress moved ahead. And there wasn't anybody shining a light to say, no, stop this, except for the parents. And so then I go back and I look again at the Parental Rights Amendment, and then it becomes clear to me the problem. And the reason it became clear is I realized that in all the studying I do of the Constitution and our founding documents and all the great people that I fortunately get to work with here at Patriot Coalition, not once did this ever come into the purview. As a matter of fact, it's talked mostly about education, that the DOE, the Department of Education, is totally unconstitutional. We talk about it in education reform all the time. It shouldn't even be there. So it wasn't such a stretch to understand what this meant now. The frightening thing that you start realizing as a parent, as a mom, is if the government starts to regulate your relationship with your child under the guise of helping you, which, remember, that's how they sold the education reform package of Common Core. This was going to make all your kids who are already really stupid, and you just didn't realize it, brilliant. Recently, we'd heard about the issues in Colorado where we had 60 families that moved to Colorado right after they legalized marijuana because their children could finally access a form of medical marijuana to keep their kids whole and safe with different varying medical issues. So those parents had this ability, this choice to say, the state I'm living in doesn't offer me the ability to seek the kind of health care that I want for my child. I'm going to move to another state. This amendment takes away everything. It takes away your ability as a parent to make choices for your children. And because, as I said, I am so fortunate to work with the great team here at Patriot Coalition. So when I talked to Jeff Lewis and Richard Fry about this, they had a lot to say about it. And I was asking them questions. There is both a House version of this and a Senate version of this. And it's really scary because any of you would, if you go and look at the list of people who have signed up for this, it is completely one-sided, all Republican. Usually people say, but see, this is a really good congressman, and he said okay to this. Yeah, well, really great people are now sitting on the Education and Workforce Committee who seem to refuse to do anything about Common Core. Under the guise of really great people, getting nothing done on behalf of you, me, most importantly, our kids. So I was really excited when we talked about the shows we were going to do coming up, that this would be one of them. And I'm now going to turn it over to the gentlemen who I know have the ability to explain this from a constitutional perspective really clearly. So Jeff and Richard, if you guys would explain this to the kind folks so they can be as horrified as I am, that'd be great.
Absolutely, and thank you, Dawn. And you really left something out. Our gracious hostess is Ms. Dawn Wildman, and she's Patriot Coalition's National Political Director. I'm Jeff Lewis, National Director, and Richard Fry is our General Counsel. And on the screen, because I know we have some folks who are listening but not watching, just to frame this, tonight's webinar show will walk you through HJR 50, Parental Rights Amendment. And the Parental Rights Amendment was authored by Convention of States Project Director Michael Farris. It grants government authority over your children that the Constitution has never authorized. Now, there's a link on the screen where you can directly download a PDF of HJR 50. It's in the Patriot Coalition documents folder, and I will add it to the recap email, which we were negligent in last week with that one. And before we get, I just want to share one quote from Supreme Court Justice Antonin Scalia. And you don't hear this coming from the Supreme Court Justice very often. Justice Scalia said, the Constitution means what it says. You figure out what it was understood to mean when it was adopted, and that's the end of it. And before I get into the slides, I want to show you real quick, for those that we didn't show last week. If you go to congress.gov and just type in the search bar HJR 50, you could do this for any bill. It'll take you to this page where you can not only, now the link to the PDF that I just showed you on the PowerPoint is just the bill itself. But if you go to congress.gov and look at this, look this up, you'll see that there are currently 80 co-sponsors. If you want to read the text of the bill, you can click there. If you want to see what kind of actions have been taken. But I strongly recommend you, no matter where you live, go here, click on co-sponsors, scroll down, and you can search by state. So whatever state you live in, I know we've got some listeners, viewers from Colorado. You click on Colorado, it shows that there was 2, and it'll give you the names of the 2 co-sponsors of HJR 50, Parental Rights Amendment, Congressman Lamborn, Congressman Kaufman. We've been working on for several hours, and it's not quite done yet, a template letter that you can send to your congressman to say if they're already one of these co-sponsors, that they need to withdraw their sponsorship of this dangerous amendment. If you haven't been to parentalrights.org, this is Michael Farris's website that has been promoting this amendment, variations of it, over several Congresses. It's been introduced in at least the past three, the 111th, 112th, and 113th Congress. Now you can find the amendment there. You say, well, there's been thousands of proposed amendments come through Congress. Well, keeping in mind that Mr. Farris is also the co-founder, director of the Convention of States project that's attempting to trigger an Article 5 convention. While you were there on their About page, if you look down here at the mission, under our mission, you'll see this item 3, by encouraging state legislative resolutions in support of the Parental Rights Amendment. Now, it doesn't take any stretch of the imagination that if Michael Farris, through his Parental Rights Organization, are soliciting Congress to propose this amendment via the First Amendment method in Article 5, and that they're also approaching state legislators to adopt resolutions in support of the Parental Rights Amendment, that if there were an Article 5 convention for proposing amendments, and if Mr. Farris was a delegate, or any of these legislators that they've influenced, that the Parental Rights Amendment is a good thing, that this may very well be one of the amendments that would come out of an Article 5 convention for proposing amendments. So I would also encourage you to click on the State Legislative Resolutions page, and that'll take you here, where you can scroll down, and they have all 50 states to give you an update of where they are in their efforts to get the Parental Rights Amendment supported via state resolutions, state legislation.
Well, and one of the things I meant to say, I wanted to say too, for those that, because I keep telling you, Jeff, one of the things that I think will really help people understand how bad this is if you're in the education reform Common Core fight, because you get that things don't often are not as they seem. You get that if we've been telling people for years now, you keep focusing on the curriculum, and the government says, we're fine that you're focused on the curriculum because you're saying to us you are completely okay with federal government completely taking over all education in this country. You just don't like the particular curriculum. And that's the big deal about this amendment, too.
Absolutely. Also, would strongly encourage you to go to News with Views. One of our allies in restoring constitutional governance, Ms. Publius Hulda, wrote a very good article about this last July, titled Parental Rights Amendment, Selling You, Your Kids Out to Big Government. And she goes into great detail. But go check out Publius's article on this as well. And with that, I'm going to get back to get into the presentation. We talk about our rights and liberties. Our rights come from our Creator. And I'll go forward a slide first. You recall in the Declaration of Independence, in the second paragraph, it says, we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. Well, unalienable was not just put there to make it sound fancy. If you look in Johnson's 1755 dictionary, this is 32 years before the Constitution was written. So what did the framers understand unalienable to mean? A hereditary right, and they used the F as an S sometimes. Hereditary right should be kept sacred, not from any unalienable right in a particular family, but to avoid the consequences that usually attend the ambition of competitors. If you go to Webster's 1828 dictionary, unalienable, not alienable, that cannot be alienated, that may not be transferred as unalienable rights. Fast forward a couple, almost 200 more years, to Merriam-Webster's 2014 dictionary, and it actually sums it up even simpler. Unalienable, impossible to take away or give up. So when they wrote the Constitution, it was to uphold those principles and values that the framers had expressed in the Declaration of Independence, that recognized that we had certain rights endowed by our Creator that are unalienable. We can't give them away. We can't allow anybody else to take them away. And one of those is parental rights. And Counselor Fry is going to explain that in more detail. But the whole premise behind, well, before I get into that, the proponents of this Parental Rights Amendment, that say we need the Parental Rights Amendment to protect parental rights from something. Well, that's something that they're talking about protecting us from. We already have a protection for. The Supremacy Clause of the Constitution says this Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land. The judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. Which means regardless of any law any state makes, or anything else in the Constitution that conflicts with that, the Constitution is the supreme law. The proponents say that we need this Parental Rights Amendment because Congress, and primarily the President and the Senate, via their treaty-making authority, or treaty-making powers, are entering into treaties that threaten or jeopardize parental rights. And that because we have President and U.S. senators that are usurping the Constitution, violating their oath, passing laws and specifically adopting treaties that are not in pursuance of the Constitution, that we need to amend the Constitution. So what did the Bill of Rights say about protecting those unalienable rights and the powers of this federal government, including the President and the Senate in their treaty-making capacity? That the power is not delegated to the U.S. Constitution. And since we're talking about a God-given unalienable right that we can't give away or allow anybody else to take away, that's one that's reserved not even to the states. That's one of those that's reserved to the people. Now, you can argue that the states may have some authority and responsibility to protect the rights of the child's interest, but there was never anything in the Constitution granting that authority or power to the federal government. And it's arguable to the extent that you would find it in the state government. And just like Dawn referenced, if the state's got some screwed up laws, you might could move to another state to either escape something that was bad or in pursuit of something that was beneficial to you and your family. But when they constitutionalize something in the federal Constitution, there is nowhere in the United States that you can go to get away from it or to seek it out if it's something that benefits you and your family or is in pursuit of protecting your God-given rights. So what would H.J.R. 50 do? It would take your parental rights away in order to protect them from treaties. And as Richard had referenced, that's kind of like what George Bush said, that he needed to suspend free market principles to save the free market. the Supremacy Clause is being violated by the President and Senate in their treaty-making powers, such that unalienable parental rights are being threatened by international law and treaties. That's the problem they're proposing that we need to deal with. And their solution, in order to protect unalienable parental rights from treaties and international law, HJR 50, the Parental Rights Amendment, would constitutionalize the governmental interest. In essence, give parental rights to the federal and state government. Not just the federal government, to federal and state government. So, Richard, if you've got yourself muted or you're being mighty quiet, you can unmute yourself. I want to go through HJR 50 section by section, and you explain to the folks what they need to glean from each of these sections, starting with Section 1. Or if you have any opening comments you'd like to supplement or correct anything I screwed up, feel free.
Hi, Don and Jeff. I appreciate being here. Just as a preface, I would say you talked about inalienable rights. And I just do a quick overview of really what those are, where they come from, and why we're talking about them. Our republic is based on Judeo-Christian principles, and whether you believe in God or not, it doesn't matter. That's just a statement of fact. And those principles, the primary principles are, number one, that we do have a God that is sovereign over all of us, that God has given us free will. And another word for free will is, of course, liberty, the ability to choose how you're going to live your life, etc. Because of free will, because of our liberty, we are personally responsible and accountable for the actions we take. And one way to look at this as well is that a duty that you owe to God or that God has imposed upon you is a right as it relates to the government. The Second Amendment is a prime example of that. The citizens have a duty to protect their families. They have a duty to serve in the militia of the states. Therefore, they must be armed. So they have a right to have the federal government not infringe that ability to be armed. That's where it comes from. Their duty creates a right. And if we look at the Declaration of Independence, that's exactly what it says as well, that we were endowed with inalienable rights by our Creator. So it's just a carryover of that basic principle that we have. And certainly the parental rights are one of those inalienable rights that God has placed upon parents. Parents, under the Judeo-Christian principles, have a duty to feed, to care for, to clothe, to educate, and generally upbring, teach their children. So that is a parental duty, and therefore it gives rise to a parental right. And as you said, Jeff, there's nothing in the Constitution whatsoever that places that right under the authority of the federal government. And of course, the federal government is a government. It's not a sovereign government. It's a government of enumerated and limited powers. It has no inherent authority. And so if it's not there in the Constitution, it doesn't have it. And it's not there, and they don't have it. And the purpose of Resolution 50 is to create an authority in the federal government over parental rights. Does anybody have any questions on that?
I have a statement. We're in presentation mode, so they can't ask questions yet. But I'd like to point out something you and I discussed. That's to me, I didn't have to get to the really scary sections in this amendment before the red flags started going off, because the liberty of parents to direct the upbringing, education, and care of their children is a fundamental right. Well, define fundamental. There's a difference between a fundamental right and an unalienable right. The UN likes to call our rights fundamental. And if you don't make a differentiation between a right and a privilege, or even liberty, you can be at liberty to do something that may or may not be construed to be an inalienable or unalienable right. But parenting is an unalienable right. So it concerned me right out of the gate that they're referring to liberty of parents to raise their kids and take care of them is a fundamental right, not an unalienable right. It's more international language that ignores the Judeo-Christian principles and values that our country was founded on.
Well, this is the standard ploy that's played by government and special interest groups, where the sophistry is in the language. They're playing with the language, and they want to define one thing to mean something else, etc. And you're right. You're absolutely right. People think they understand what this means, and I'm not sure they do. I mean, one thing, when you talk about liberty, I think that rights, duties, right, give rise to rights, and rights give rise to liberty. So when they talk about the liberty of parents, it's somewhat removed from a right and maybe removed from a duty. And you're right. But when they talk about a fundamental right, what does that mean? Now, if you look at the Declaration of Independence, you kind of want to equate inalienable or unalienable, is really the constitutional term, unalienable right with a fundamental right, with a God-given right. But see, that's not really clear here. And they certainly don't make note that it's unalienable. So it's extremely vague in terms of what they're talking about. And the other thing that's interesting to note here is they really talk about three different items under this liberty: upbringing, education, and care. And as you go through here, you'll find out in Section 2, they don't talk about upbringing and care. They talk about education. So what's the status of these two other, what they call liberties, and what do those even mean? What does upbringing mean? What does education mean? What does care mean? Ultimately, something like this would have to be defined by the courts, and most likely it would first be defined by an administrative agency set up in the federal government to administrate the parental rights that the government has taken over. And so you're going to have bureaucrats that initially will make these determinations, and then the courts will have to step in and ultimately define them. So from the get-go, we have a real problem with this under Section 1 because it's really vague and ambiguous what they're saying. Now, a lot of people think they know what they're saying, but the reality is we really don't know what the authors of this are saying.
And if I may, Richard, in between those executive branch or administrative agencies that would come up with the terms and policies, were this amendment to be ratified, it would first go back to Congress, and under their authority in Article 1, Section 8, Clause 18, the Necessary and Proper Clause, they would write laws, and they would be the ones that would decide or create new agencies and give them guidance on what Congress's understanding these terms mean. Well, and they may or may not define them.
Let's be clear. When you say guidance, let's be clear what guidance has been in the past. Guidance in the past has been a delegation by Congress of its responsibility to legislate, to make laws. That's what it's been. And so what you have is, for instance, the Affordable Care Act or the Patient Care and Protection Act. That was like a 2,300-page law, a monstrous law. Now we have over 20,000 pages of regulations some of which touch on things that aren't even mentioned in the actual law. So that's what you can expect. Another example.
Congress does that in part so they don't have to assume any responsibility or any of the backlash for those policies and regulations, because they can say, we didn't do that. The executive branch did.
Oh, well, no, I'm sure that's not correct, because remember, they have a duty under our Judeo-Christian principles. They have a duty of personal accountability. So I'm sure that what you said is not true. I'm sure they're not trying to pawn off their responsibility.
Right.
They wouldn't do that.
They wouldn't do that. So let's look at Section 2, which, as you said, it ignores or doesn't speak to upbringing and care of the children. Section 2 just delves into the education of your children.
And it doesn't even, we don't know what education means really, but it doesn't talk about education in general even. It just talks about direct education. Parents have a right to direct education. Well, I don't really, you don't know what that means. Now, they've given a partial definition. It includes, and see right there they say it, this isn't everything. When they use that word includes, it means it includes but is not limited to the right to choose public, private, religious, or home schools, and the right to make reasonable choices within public schools for one's child. Well, what else is involved in that, right? We don't know. I mean, it says it includes, but it doesn't give you everything. We don't know what else it includes. So very vague, right? And we're talking about parental rights, a fundamental right, probably the most important responsibility and duty that a parent has under Judeo-Christian principles. And so we're going to leave it open in the air. And then they use the term, the right to make reasonable choices. Well, reasonable to who? Reasonable under what standard? Who makes that decision? I've worked in domestic relations in my career, and I've had to deal with social services, particularly in cases where we have a child in need of care situation. And what I have experienced virtually every time I've dealt with that is I'll get a young lady right out of college who is not a mother, is not a parent, is not a family, and she's telling a family how to be a family, how to be a parent. It's absurd. And so, you could expect the same thing. That's the way the government operates. They'll set up the bureaucracy and they'll staff it, and then you'll have somebody that doesn't know what they're talking about that's going to direct you. And how do they do it? Primarily, they do it by some kind of manual that a bureaucrat makes up. So it's just obscene. That's what you can expect.
I have to interject. Keep in mind, as we're going through this, the whole purpose that this proposed Parental Rights Amendment is being put out there is because they're saying that we need this to protect your parental right from treaties, international law. So we're going to protect your rights by taking them and deciding lots of things.
Jeff, at the very best, what this will do is it will make the federal government a joint tenant or a tenant in common with your God-imposed duty to care for your children, to guide and direct and raise your children. That's what it does. Now, I would almost as soon go into business with the mafia than the federal government, frankly. Let me tell you something. It is not pleasant. Like I said, I've worked in these child in need of care cases, these SRS cases, and it is not pretty what they do to these people. They will pry and nitpick into every facet of their lives. They'll come in and check the corners of their living room for dust. I mean, it goes on and on. So this is the last thing somebody wants. And the other funny thing about this is, the government cannot enact a treaty that's inconsistent with the Constitution. So there has to be, the treaty has to relate to some authority that the Constitution has. The Constitution gives no authority over child care. Therefore, a treaty cannot be the supreme law of the land because there's no ability for the federal government to regulate and be involved in child care.
I'd like to ask a legal question here, Richard.
Let me just finish this point though. By this resolution, now they legitimize the ability of the federal government to adopt the UN Convention on the Rights of a Child, which is exactly what they say they're trying to protect from. So it's an absurdity.
And that would be, and you can expound on that more in the next section, but I have a legal question about this one. Because it says here, you speak to the legal principle of a general provision as opposed to a specific provision. And that if there's a specific provision that's in conflict with the general provision, that generally it would be viewed that, generally speaking, this is the law, unless there's some other area carved out. And I see a carve out here because it speaks to that you were talking about the reasonable choices. The parental right to make reasonable choices within public schools. And because it doesn't say they have the right to make reasonable choices in private schools, religious schools, or home schools, it only constitutionalizes their right to make reasonable choices within public schools. Is it a stretch of the imagination or legally for a bureaucratic body or a court to say, because they did not say, if it was their intention for you to be able to make reasonable choices in all of these schools, they wouldn't have specifically stated that your right to make reasonable choices was for a specific type of schools.
Well, yeah, that would be true. I mean, what are we to assume that they're saying that you can make unreasonable choices on these other items? It's not very clear, is it? So what's the standard? They don't give us a standard on any of these other items, just on this one. So what is it?
So
is it
you may not have
reasonable?
any choice. You may not have any choices on private, religious, or home schools, and they're only going to give you the right to make reasonable choices as it relates to public schools.
Yeah, well, you don't know.
You don't know. You can drive any position that you want through this section. Very dangerous.
Yeah. It's going to be, like I say, it will be opened up to federal bureaucrats and ultimately the federal judiciary to make these decisions. That's what will happen. It's very, 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 very dangerous. And look, the government's primary duty, maybe its only duty, is to secure or to protect. That's basically what it means, to protect our fundamental rights and derivative rights that come from those. That's where the Second Amendment comes from. It's a derivative right to the right of life. And so, now we're talking about a fundamental right and an unalienable right of the parents, and they're talking about reasonable choices when their job is to protect. It's not to commandeer or to co-opt or to usurp the citizens' rights, but it's to protect them. And so now what they're doing is they're taking them, or at least taking an interest in them, if you will, and then they're saying that they're going to judge this parent's decision by whether or not it's reasonable. Well, let me tell you something. Is it reasonable to send a kid to a swimming pool when it's 65 degrees outside? Or should you wait to 85? There you go. I'm serious. You could get into this all day long. What's reasonable or not reasonable? My position is that we have to give, out of the interest of protecting unalienable rights, the highest deference to parents. All right, and we have different backgrounds, different religions, maybe devoted to the religion at a different level. There's so many aspects, cultural aspects. It's crazy. This is all going to be thrown up in the air, and they're going to let the federal government decide.
Right. Now, in Section 3, it says, neither the United States nor any state shall infringe these rights without demonstrating that its governmental interest as applied to the person is of the highest order and not otherwise served. Now, Richard and I sat down with Dr. Edwin Vieira to discuss this and other things back in the spring. And when Dr. Vieira got to this section, he's reading it, neither the United States nor any state shall infringe these rights. And he paused. He said, well, we should have stopped right there. Even if you were in agreement with their terms and definitions of what parental rights were and what you were at liberty to do as a parent in sections 1 and 2, when they get to section 3, all bets are off because they change it from being in the child's interest to the government's interest.
And notice now what we've done. In section 1, we're talking about 3 items that are part of the liberty of a parent, right? In section 2, then we're talking about one aspect of one of those 3 parts, one aspect of one of 3 parts. Now in section 3, we're back to all 3 parts, everything we're talking about now. That's dangerous, that flip-flopping. And sometimes there's a psychological purpose for that because it can be used to distract one's attention from what really is going on. We saw that used extensively in the 2012 National Defense Authorization Act.
Absolutely.
Now, and here's the other thing, too, now, of course. The federal government has no interest whatsoever and has no authority. That's really the bottom line. It has no authority to deal with parental rights. This establishes, when it says its governmental interest, it assumes a governmental interest. And creates it right here in Section 3. That's what it does. So if somebody's saying they want to restrict or shrink the government, that's not what this does. This expands governmental power. And let me tell you, you're going to have a department or an agency that springs out of this baby. You know, it'll be the Federal Department of Child Care or whatever they want to call it. So that's the other thing. Do we need a bigger government? Is that, are we happy with the way that the government has handled our rights and our money such that we're willing to let them handle our kids? Not for me.
and if you recall, when we were just sitting down with, I call him Dr. Vieira, like Counselor Fry. He's a constitutional scholar, constitutional attorney. In the good sense that he actually believes the Constitution is the supreme law of the land and understands it. Can you explain to him the compelling state interest, the compelling government interest doctrine, that judicial doctrine that Dr. Vieira was discussing with us?
Well, what he was talking about, it's not the compelling interest, but it is that term that's being used, governmental interest. And there's this false judicial doctrine out there whereby the Supreme Court has determined that any right can be infringed if there's a sufficient interest by the government. Well, no, that's not the way the Republic was set up. I mean, that's a fundamental problem that we have in our government right now. There is no interest in the government, right? And they've used this, as he calls it, a false judicial doctrine. And what this is going to do, it will constitutionalize a doctrine. I mean, the Congress could, may not be likely, but they could do away legislatively with such doctrines. They can say these doctrines don't apply. They're not going to be recognized. They're made up. Once you stick in the Constitution, the Congress's power goes away. They don't have the power to overturn it.
In fact, they're then bound to uphold it.
Exactly. Absolutely. Every officer of the federal and state government will be under oath of office and to protect the Constitution, including this. They'll be under an oath to protect the governmental interest, the governmental rights in your children, which, they have no rights in your children.
Just socialism. Communism. Well,
yeah, I mean, this attitude is a socialist attitude. It's the collective. They believe that the parents are simply caretakers or agents of the state for caring for these children. And the children, it's the interest, the ultimate interest in the children is that of the collective. The government has the biggest interest in the children, and maybe the only interest, right? That's really what this is all about, and that's common in the communist societies, Russia and China and Korea and those. I mean, that's just the way it operates. So they can tell you how you're going to raise your kids, on and on. What shots you give them. I mean, everything. How they're going to be educated, when, all that nonsense. So that's really where this is going. That's another aspect of this.
Absolutely. One last thing on this section, just for clarification. Who's going to determine what that governmental interest is? You think about it as a parent. You have more interest in areas of decision making related to your child than you can even put to paper. And as you grow as a parent and your child grows, you find out more and more that you have more and more decisions to make about what's in your child's best interest. And this would constitutionalize giving the government that authority, and giving the government the authority to determine how high that governmental interest is, and that it's not being served somewhere else. I mean, it's wide open.
That's absolutely true. And here's the other thing that you need to think about. Why they're talking about doing this, formally making the federal government a co-owner in your parental rights, they are in essence carrying this out already, for instance, by Common Core. Common Core is taking over the education. It's nationalizing, federalizing education so that it's the federal government and the people with the special interests behind it. And who are those special interests? It's the Bill and Melinda Gates folks and the National Association of Governors, or National Governors Association, that was started and funded and continues to be funded by the Rockefeller Foundation and the Ford Foundation. The Rockefeller Foundation, the Rockefeller family, is one of the leading supporters and instigators of the United Nations.
Well, and in fact, Arnie Duncan has said flat out that he wants the school, your kids, to spend all of their time, and you as parents, that would be the center of the village, much like our churches used to be. So they are completely okay. This next section is the one that just, if you don't understand who these people are, this is where it lets you know exactly who they are.
Well, yeah, and Section 4 is bizarre, because what does that mean? It can mean one of two things: either this right of parental decision making regarding the end of life is taken away, or it can't be impaired. But you don't know by this wording. It's like saying, it's like an old Saturday Night Live skit that I like, and I use it as an example, where an engineer comes in a nuclear plant and he tells one of his subordinates, "I'm going on vacation." You don't need to really worry about anything. The only thing you got to make sure is, or remember, is a nuclear reactor can't get too much water. Okay, so then he leaves, and of course there's a problem. So one of the subordinates wants to flood the place with water, and the other says, "No, we need to take water out," because it was ambiguous, and that's what this is. What in the world does that mean?
Well, I just thought it was so interesting coming from people who would espouse to be pro-family, pro-life, pro-anything, that this says to me as a woman that,
Does this mean honor killings?
Well, does it mean abortion now is okay? We're not going to, if you are a parent, quote-unquote parent, that you can totally, we don't want to mess with what you do at end of life or even make a decision of where that is, so...
Well, I mean, you're absolutely right. This could be a pro-abortion provision in here, such that the people have a constitutional right to not to have their decision to end the life And some states are trying to define that at a certain trimester or at certain stages. They've got this awareness of pain legislation going out there. Some states do, and that this may very well protect that interest, if indeed there is any such interest in killing children. But this is scary. It's very scary.
Well, yeah, because the one thing it says that we'll take our hands off of, I mean, this is the way I've always read it, is the one place we don't really care about, the one place where we're just going to leave it up to you to do whatever you want, is when it's about ending life, period, right? So it's up to you to decide where that is. And since most of these people
would this protect honor killings?
Right, and these people very much.
Good. It's interesting too because they don't talk about a child; they talk about end life. I mean, and that's the standard shell game that these politicians play, right? Because we've been talking now in this article, we've been talking about children and parental rights, and now all of a sudden we're talking about end of life. Right, so everybody's just assuming we're talking about, a child, a living, breathing child, and not necessarily so. It could be an in vitro child, right?
Right.
So, I mean, it's pretty scary.
And in Section 5, if we weren't already deep into Pandora's box, Section 5 says no treaty may be adopted, nor shall any source of international law be employed to supersede, modify, interpret, or apply to the rights guaranteed by this article. And on the surface,
it goes right along with that. It wouldn't have to anymore.
But on the surface, it's given the public and these legislators, these 80 co-sponsors, I'm going to give them the vast majority of them the benefit of the doubt, but they don't know what they're reading. But they probably have public educations. That no treaty in the future could trump this amendment to the Constitution. Richard, Counselor, can you explain why this is another rabbit hole, Pandora's box?
Well, this is what I talked about earlier. One of the aspects of this particular section, Section 5, the standard that we have now under constitutional law is that no treaty, or certainly no international law, can impact domestic law. It may apply to some of the things that our government agrees to do, but doesn't have anything to do with us as citizens. And the treaties don't do, and a treaty cannot do that. The only time a treaty really impacts domestic law is if the object of the treaty is a power that's already been given to the government. Now, there's some people that want to argue, and this is ridiculous, but we've been heading down this road, that the treaty power is a all-encompassing power. So they can basically make a treaty on anything, and that's fine. Well, that's ridiculous. That's not what the founders say. The Federalist Papers talk about it, and there has to be some authority, other authority. It's not just to say, well, we can make a treaty, therefore we can make a treaty that will take away everybody's guns. So that's one aspect of it. This would give rise to the ability of them to adopt international treaties that would impact domestic law. That's what this opens the door to. Now, the other thing is that's a Trojan horse, because there's a rule of interpretation that says you have to give every provision some meaning. That the legislators don't put meaningless terms and phrases in a law. For instance, you don't see normally, you and I have in some of these deceptive bills, I guess, but you do not see a bill that says this bill must be constitutional. Well, you don't have to say that. It's redundant and a waste of time, because all bills have to be, it's inherent in a bill, they have to be constitutional. They have to be pursuant to the Constitution. So this term, this phraseology, this provision is either a superfluous, meaningless phrase, or what it's telling us is, and this is the Trojan horse aspect of it, that this particular amendment may be protected from treaties modifying or changing that particular subject, but none of the rest of them are now, because none of the rest of them have that provision in there, right? So that's going to be open for discussion. Is this a Trojan horse? It certainly could be.
And that's what Dr. Vieira was speaking to, was if there was a need for this provision in the Constitution to protect us from treaties, it would have already been there.
Yeah.
And actually, it is already there, and it's called the Supremacy Clause.
Exactly, absolutely.
And this provision here would flip the Supremacy Clause on its head for all the rest of the Constitution that doesn't have this protection.
Well, let's look at what's going on here. You know, this is the standard Rahm Emanuel crisis situation, right? This is Al Linsky. These folks are developing a crisis, and the crisis is that the United Nations is trying to get control of our children with this Convention on the Rights of the Child, right? And so we have got to be afraid of that, because they're gonna weasel their way in through international law or treaties and regulate our child care, which they can't do. That would be totally unconstitutional, right? And so they're scaring people into doing exactly what they're saying they're trying to protect them from, right? It's bizarre.
They did the same thing with the Small Arms Treaty.
Yeah, well, and when was this? Let me ask you this: when was this successful? And it's been successful. This technique has been successful many, many times. But when was the biggest, one of the first, one of the biggest times that this technique that we're seeing right here has worked? The Federal Reserve Act.
So it's Creature from Jekyll Island.
Absolutely, the Federal Reserve Act, because the people that wrote that legislation were the money trust people, Rockefeller and J.P. Morgan, that were identified and investigated by Congress and identified as the money trust, people manipulating the markets, etc. They're the ones that got together secretly and wrote the bill. See, now they don't do it quite that way. They meet behind closed doors, but they don't meet secretly, because you have the legislators or state legislators get in a room with ALEC, which is basically run by corporations, and so they get in a room with corporate attorneys and lobbyists, and they all have joined this club called ALEC, and therefore they can get away with it. It's a captive lobby institute, and that's what they're doing. They're doing the same thing like with the Federal Reserve Act. The special interests are handing this legislation to the people, to the legislators, and it's getting rammed down our throats. And this is exactly what happened. And then what did they do? They went out and created non-governmental organizations, right, and set them up as if they were grassroots organizations, set them up in every state in the union, and then started organizing letter-writing campaigns and propaganda campaigns, etc., to make it seem like and put a lot of pressure on legislators, right? And you don't need very many people to do that, right? Because just a few, maybe 10, 20, 30 in a district that gives calls and letters and constantly out there and gets the media to write letters, right? So, I mean, this is the same kind of stuff we're seeing. And the same kind of stuff we're seeing with the Convention of States, trying to get an Article 5 convention going as well.
Right. And just to wrap this up, this push to get control of the education of your kids and get control of your kids has been going on since before most of us were kids. And
absolutely.
A couple weeks ago, we did a show on the Reese Commission and the Cox Commission, the Reese Report, from back in the 50s, where they investigated these institutions and NGOs. And some research we were doing this week, we ran across, and that's over 2,000 pages, just the Reese Commission report. The Volume 1 of the report of the President's Commission on Higher Education also includes additional interesting comments, and this is in the Reese Commission report. And we found it very interesting. Preparation for world citizenship. Now, this is the Eisenhower administration's report on higher education. In speed of transportation and communication and economic interdependence, The nations of the globe are already one world. The task is to secure recognition and acceptance of this oneness in the thinking of the people, as that concept of one world may be realized psychologically, socially, and in good time, politically. It is this task in particular that challenges our scholars and teachers to lead the way towards a new way of thinking. That was on page 16. On page 20, there is an urgent need for a program for world citizenship that can be made a part of every person's general education. Now, with this Parental Rights Amendment is being fear-mongered that we need this to protect us from international law and via the treaty powers. But the backdoor attempt or the backdoor victory that they would gain from this is for the United States government and state government to get full control over your children, and specifically the education of them, and then generally whatever other governmental interests they determine is not being otherwise met.
And this is where it sort of piques my... I'm sorry, go ahead.
You don't have to worry about the big bad wolf that's at the UN, because they're going to lead you sheeple that are buying into this Parental Rights Amendment protecting your rights. That by if this country survives another generation, they will have complete control, especially if they get this amendment passed, of your children's education. They want it from cradle to grave because it's their intention, and this is straight out of the President Eisenhower's report from the President's Commission on Higher Education from 60 years ago.
I think this may be the Truman administration that did the report. Truman? I think so, yeah. But now remember, the Reese Commission, who did they identify? What did that congressional investigation reveal was behind these non-governmental organizations, these tax-exempt foundations? What was one of their main motives? It was to take control of the education system. And who were they? Who set these organizations up? The Money Trust. And specifically, who were they looking at? They were looking at primarily the Rockefeller Foundation, the Carnegie Foundation for World Peace, or whatever that nonsense is, and the Ford administration. And in fact, they found that there was an agreement between the Ford Foundation and the Rockefeller Foundation I think Carnegie took the higher level of education and worked towards getting control of it, while the Rockefeller Foundation worked on getting control of the K through 12 education, and that's what they've done.
And that's the part where this became more of on my purview, because if you've sat through enough of the hearings before the Education and Workforce Committee, and some of the people who signed on to this, some of the congressmen who signed on to this first, are those that sit on that committee, and you've watched them question Arne Duncan about whether or not the government has taken over the curriculum across the country, and have a sitting representative say, well, I'm asking you this question because, and I don't think it's tinfoil hat fringe thinking. Well, okay, right there you've already denigrated your constituency, because that's who you say is having you ask the question. Arne Duncan laughs and said, no, we haven't done that. And he leaves it there as if that's okay. These are the same people who signed on to this. That's what's really frightening.
Absolutely.
Oh, yeah. It just keeps going on, and the corruption is amazing. It's big dollars. Now, let me explain another little aspect of this, which is just amazing. Before they started setting up these foundations, the Rockefeller Foundation and Ford Foundation and all that, they were spending their own money trying to influence politicians and buying in politicians, etc. They were spending their own money. if you noticed in the Reese Commission, what they found out was once they set up these nonprofit tax-exempt foundations, for every dollar that they spent, the government was spending on average $9. That's $9 of your money and my money. We're paying to strip ourselves of our own liberty. That's one of the reasons they did the foundations. And, of course, they use the foundations to hide their assets and to conceal what they're doing, right? You have a cover. But it's absurd to think that we're paying to strip our own liberty away.
Richard, in the interest of keeping the recorded part of this that we're going to be sharing under 3 or 4 hours, if you're not familiar with this bill, there's one. Let me get out of there for a second. Now, Richard and I, as we've gone through these sections tonight on the Parental Rights Amendment on HJR 50, have made references to Dr. Vieira and an interview that we did with him. If you go to where I was just at, to our Article 5 site, rejoinerDie.com, and scroll down just a little bit, you'll find our Article 5 playlist. If you expand that so you can see it, you'll see the fourth video down, Dr. Edwin Vieira on the Parental Rights Amendment. Watch that video. You can go directly to our YouTube channel on the Patriot Coalition YouTube channel or my PatriotWatchdog YouTube channel. Watch this video with Dr. Vieira on the Parental Rights Amendment. If you need a refresher or more clarification on what this resolution will actually do, HJR 50 in Congress, and just a refresher in memory, you need to go to parentalrights.org, scroll down a little bit on their about, what their mission is, click on the state legislative resolutions so you can see this page at parentalrights.org to see whether they have been actively involved or had any success in your state getting your state legislators to pass their Parental Rights Amendment resolution. They're hitting this from both sides. And I went to the North Carolina Lieutenant Governor Dan Forrest held a town hall with Michael Farris in Hendersonville, North Carolina last Monday. And at that town hall, which I videotaped and will be sharing that shortly, he admitted on camera that he plans to be, and I'm paraphrasing a little bit here, when I share the video, you can watch it and hear for yourself, that he expects to be, if they can get enough states to apply for his Convention of States application for an Article 5 convention for proposing amendments, and there's a convention called, he fully expects to be a delegate from Virginia. And he also has aspirations to be the George Washington of this convention and actually chair the convention. And the question I would ask that you consider is it unreasonable to expect or suspect that a man who has started an organization such as parentalrights.org and drafted amendments such as the Parental Rights Amendment and get it introduced in at a minimum of 3 Congresses, 111th, 112th, 113th, that if that man found himself as a delegate at an Article 5 convention, that he would not also propose that amendment there, especially after having built such a consensus of alleged grassroots and state interest and congressional interest via HJR 50, where he's got 80 co-sponsors there. And is this the whether you want to call into question his competency as an attorney or as a constitutional scholar, or perhaps assign a more nefarious agenda, or that he might be an opportunist, or he's just an idiot. I don't know. You can pick and choose, or maybe he believes that he's sincerely doing the right thing for the right reasons. Well, regardless of what this man's motivations and the other proponents of this Parental Rights Amendment, or that are trying to trigger an Article 5 convention, this is the kind of amendment that you will see. And we could do another 4 or 5 shows easily just going through and analyzing other crazy proposed amendments by the same alleged conservative Christian factions that are working morning, noon, and night to trigger an Article 5 convention. And some of them are just as bad as this one, if not worse. This does not identify the correct problem. It is not a solution. And if we sit on our hands and do not just not help them, actively do everything we can to educate our fellow citizens, our state legislators, our members of Congress, anybody that will listen, to stop this crazy town train toward doing the open heart surgery on our Constitution, we will not have individual rights. There will be no recognition of our God-given rights. You will only have privileges that the state determines are reasonable. I got a couple more wrap-up slides here, and then I'm going to stop the recording. As we showed you up front, and we're almost ready to pull the trigger on launching our new website, which we've been sharing with you guys bits and pieces. Visit us at PatriotCoalition.com, and right on the homepage there is a link to the new site, new server. We've added a lot more stuff in the past week. Visit us on Twitter and on Facebook, and by all means, go to YouTube. I apologize for being behind in uploading the video archives of our Nation on Fire show, because we've got a lot of things, a lot of coals in the fire from coast to coast, and a lot more coming, especially over the next couple of months. Would you like to contact our national staff? Here's our email addresses. They're all at PatriotCoalition.com. Myself, Jeff at, our General Counsel, Richard at, our Deputy Director / Director of Operations, Steve Sadler, D at, or our National Political Director and hostess or co-host, Ms. Dawn Wildman. Our National Political Director would be Dawn at PatriotCoalition.com. We'll see you next Tuesday night at 9 p.m. right here at Nation on Fire on join.me/Patriot Coalition. And remember, defending life and liberty is the pursuit of happiness.